Inheritance issues. In a nutshell, family disputes over property. Now that's a very real experience, and that's our topic today. Hi, I'm Charlotte Volsch, certified probate real estate specialist and trust advisor, and an expert at helping executors and administrators with homes in probate. So let's talk about inheritance issues while dealing with the probate process. Now, one very real and very possible situation that can come up is, what do you do when more than one person inherits a property and one person wants to sell and the other person just doesn't want to sell? Now, as you can imagine, this could be awful tricky and very controversial. And this is where your probate attorney may need to step in. But there are a variety of solutions that can be put into place. Now, first, you want to verify that the parties involved either own the property outright or have been designated as the beneficiaries or heirs. Now, another way of checking is, has the property already gone through the probate process and then through that process designated that it was inherited in the will? If so, does the will give guidance on how the property should be distributed? Now, when I was helping Eunice with a home in which she had inherited 50% of the property through a probate because her fiance had drafted a will that stated that she would receive 50% of the house upon his death. Note I said drafted, so it wasn't filed, so that's why it was probate. And then his daughter from a previous marriage, Christina, who lived out of state, had inherited 50% of the property from an earlier trust that Eunice's fiance and his former wife had drawn up. It got complicated, but it was resolved. Now, know that the probate courts will enforce the decedent's will, which was their last wishes. And if there's not a will, there will be an initial conversation about what should happen with the property. Oftentimes, a will have in it that both parties, typically siblings, own the property in equal shares, and they own the property together. At that point, the two parties involved will need to figure out if there's a mortgage, how that mortgage is going to be paid off. Next, it will be important to determine if there's any equity in the property. So an appraisal will give that information to all parties involved. If the property is in probate, a probate referee, which is their appraiser, will be assigned to the property. Now, that's a great way in probate to find out what the current market value of the decedent's home is according to the courts. So if the property has very little equity, it may really not be worth a fight over the property at all. But if the property is free and clear, say, has no mortgages or debts, it can complicate the situation a little bit. So say the property is valued at $500,000. Both parties have equal shares. After all the debts are paid, like claims to the property of any kind from creditors, taxes, closing costs, commissions, all that is first paid, then the distribution of the proceeds to the parties would be 50-50. If one person wants to sell and the other one doesn't, then the person that wants to keep the property would need to pay the party off. They can do this by just liquidating their own personal funds or obtaining a loan on the property that they're inheriting to pay off the other party, and this is called a buyout. Now, if the person that wants to sell happens to win out after the conversations that occur with the attorneys, once the home is sold on the open market, both parties would receive their portion of the proceeds after all those expenses are taken care of first. Now, some of those additional expenses, when it goes on the open market, could include repair costs, and those would be paid to whomever paid for the repairs before the split takes place. Now, in the unlikely event that no agreement can be made, then all the parties would need to go to litigation. And that's where they would spend time going through that litigation process to come up with a final answer. An alternative to litigation is a partition. That's not the best scenario, as you can imagine, because it has to go through the courts. It's a court order that divides the house into portions, and actually this can get very messy and can cause problems within the family. So it's better to really resolve the real estate issue on your own. The courts will typically not require 2 or more people to own property together if they don't want to. But when the court gets involved and decides, it's never less than messy. So the suit partition in the court would most likely be done by your attorney, and that would either force a resolution of the issue or sell the property to a third party and then divide the net proceeds. I'm here on a weekly basis. If you have questions in detail about your exact circumstances, please feel free to reach out to me directly, and I'll see you next time.